Hi, good afternoon, everyone. We're going to give some folks a few minutes just to jump in. I see some numbers increasing over here on the side, so give us a second and we will get started. Thank you for joining. All right. Chris, you ready?
I am.
Awesome. Welcome, everyone, and thank you for joining us today for AANC's legal update. I am Janae Moore, I'm Janae Moore, Government Affairs Director for the Department of Safety.
I nominate Janae for governor.
I feel like there may be a vacancy or two, who knows? Today we have Chris Loebsack here with us, and he's going to talk to us about Governor Cooper's latest executive order, as well as the order that was recently issued by Chief Justice Beasley. We are so grateful for Chris, who always is willing to donate his time to kind of walk our members through the latest order. So Chris, thank you for always jumping in the call of action. Before we get started and before I turn things over to Chris, I just want to remind everyone that this session is being recorded. So if you have to jump off early or if anyone is to come in late, we will be sharing this link with our affiliate members who will be able to disperse the entire recording to everyone when needed. Also, you can always ask questions, and Chris is always lively and walks us through all of these documents, but we appreciate when the questions come in as he's going through them. So be sure to utilize the question panel below, and I will be able to ask your questions directly to Chris in real time. As well as feel free to follow along with all of the handouts that should be at the bottom of our faces, but also the links to those handouts are also in your attendee panel. So be sure to hold on to those documents. They can be downloaded. If you have any questions, email me. We'll be happy to help. With that being said, Chris, I'm going to turn it over to you, Managing Partner of Loebsack and Brownlee. Thank you.
Thanks, Janae. So for starters, folks, we're here today to talk about the weekend Saturday executive order that was dropped on all of us a week ago on May 30th. For starters, Governor Cooper entered executive order number 142 Saturday, May the 30th. It took effect on June the 1st. It applies for a period of 21 days. So everyone, we're right in the middle of it now, and we've got another week and a half or so before it is concluded in its effect, at least as it's written. But what I want to do for a quick moment is to talk about what the AANC has been doing since this came out before we dive into the substance of it. So many of you know I sit on the AANC board. Janae is the Government Affairs Director for the AANC. And once this order came out, the board immediately, through its executive committee and through Janae's efforts, reached out to the governor, reached out to the governor's team. There have been a number of conversations that have gone on, and the association has been working very hard on behalf of our membership to try and both get clarity and or confirmation on a number of issues dealing with this order. And we are expecting Janae to be able to give some more information out maybe today. Did I read that right? Oh, I turned Janae off, sorry. I put her on the spot. Hold on, she's got to put herself back on. Not yet.
Okay, how about now? Okay, good. Yes, we have been in contact with the governor's office as well as with the attorney general's office. We've been able to fully express the concerns that we see with the executive order and have had some really productive conversations. We're hoping that continues, and I'm supposed to be getting some more feedback from the attorney general's office today, as well as from the governor's office, just some remarks from him or thoughts on some of our recent complaints per se. So they've been extremely communicative, which we appreciate. And our goal is to just remain at the table in the midst of the conversation. So we'll keep you guys updated.
That sounds good. Yeah, they've been extremely communicative after they put the hammer down and drop this order on all of us without saying boo about it to anybody. So yeah, that's mighty big of them to talk to us after the fact, but I'm glad we at least got that going. So everybody on the call today, be advised, keep an eye out. I fully expect that you'll hear more from Janae or from Sherry Arbor, the president of the ANC board. One or both of them will probably have some more information to disseminate to the membership here, maybe today, maybe tomorrow, in response to all of these conversations that they've been having with the governor and the attorney general. So what we talk about today is going to be sort of the topic will be really just what does the order say, what does the order mean, so that everyone's at least on that same page. But in terms of what's going to happen from here, that's a question that a lot of, almost every client wants to know, and that's what Janae's working on with the executive board of the ANC. So keep an eye out for all communications that are going to come out, because there's going to be more about this that comes down the road here very shortly. But for today's purposes, we'll at least make sure that everyone understands what the order in its current form does say. Then we'll do our best to answer questions about what does it mean for everybody. But there are some things where you will hear me say, I don't know what to tell you. Until the governor actually weighs in and tells us what he means, I don't know what this means. There's a couple of places in here where it's just hard to understand what exactly he's contemplating, and then without more guidance, or until we get more guidance from the governor or the attorney general, we may have some unanswered questions. But hopefully we'll be able to get most of the questions, or a good majority of your questions answered, because a lot of it is spelled out in these documents. So again, there are two orders, May the 30th. The one is from the governor, Executive Order 142. And the second one is an emergency order from the Chief Justice of the North Carolina Supreme Court, Cherie Beasley. Her order, of course, deals with courthouse operations. The governor's order, he's not in charge of courthouse operations. That's why there's two orders. The governor doesn't have the power, even under the Emergency Powers Act, to tell the courthouse how to operate. And so that's why the Chief Justice weighed in with her own order. That's why there are two. So we'll talk about them one at a time and go through and answer all your questions as we go. Janae or Kristen, as people ask questions about what we're talking about, just jump in and tell me so we can get them done in real time. All right, so there's our Executive Order 142, May 30th, 2020, if you look at Kristen sharing her screen with us. So we'll scroll down a little bit and get into some of the meat and potatoes. Kristen, if you will. Scroll us down a little bit. Hopefully. Did I lose you? There we go. Okay. So the title of it was, it does directly address eviction filings. That's the purpose of this order. So he talks about all these, these paragraphs that start whereas. These are all factual findings by the governor. He's laying out the reasons why he has to issue this order, starting with the pandemic, the March 11th declaration by the World Health Organization, the emergency declaration of President Trump on March 13th, et cetera, et cetera. And so he keeps going through a bunch of these, laying the groundwork for why is it that I have these emergency powers? Why am I exercising these emergency powers in this way? He lays out that he's enacted a number of other executive orders, 116 to 122, 124, 25, et cetera, et cetera. He lays out how many people there are currently tested positive for COVID-19, and then he keeps on going, talking about healthcare administrators, hospital administrators, expressing their concerns about limiting the spread of COVID, et cetera. Person-to-person contact is necessary. We all, this is all stuff that he's been talking about before. And then he keeps on going to talk more about specifics with this second paragraph right here on this page. Whereas due to the state of emergency, many North Carolinians are working from home, staying at home. Many businesses have seen a substantial decline in demand for the goods or services they sell, causing many to close or reduce the size of their workforce. And some businesses will order close to slow the spread of COVID-19. And any disruptions or dislocations that require people to leave their homes increase the risk of spread. The economic effects of the pandemic have broadly affected business owners, tenants, and employees across the state. And because of these and other economic effects, many North Carolinians are enduring financial hardship. Then he goes on to talk about what the Chief Justice has done before. He mentions her April 13th order and her May 1st order, where she postponed court hearings, including eviction proceedings, until June 1st. And then he talks about his executive order number 124 from the end of March, where he encouraged mortgage companies and strongly encouraged them to take actions to alleviate adverse impact caused by COVID-19 on mortgage borrowers. And then he says, again, remember this was issued on May 30th, the day before the Chief Justice's emergency orders expired. They will allow court hearings to resume on June 1st. Residential tenants in North Carolina will be at risk of eviction as a result of all this. And whereas residential evictions remove people from their homes where they're safest during the pandemic and thereby increase the risk they'll contract and spread COVID-19. And then while they're now performing jobs and receiving schooling from their homes, residential evictions threaten people's ability to maintain their livelihood and receive education. Again, this is in direct response to the fact that schools aren't yet done across the state, not all of them anyway. And so he's reacting to that as an issue. And then for these and other reasons, it's reasonable and necessary that be an additional 21-day moratorium on residential evictions for reason of late payment or non-payment of rent, beginning on the date of this executive order. So he laid all that out to say that he feels bad for the residents of the state who've been affected. Many of them have been suffering from economic hardship. What he didn't say, and what he should have said in his whereas paragraphs, is that despite our best efforts to make unemployment available, we have failed miserably at doing that, and lots of the people who have been displaced from their employment still haven't gotten a nickel from the government yet, or haven't figured out what the process is to get paid. He left that part out, but it's a very integral part of this. The truth is that lots of people have been unable to get their unemployment benefits. Lots of the residents in the multifamily communities who should be receiving benefits haven't been, or they're receiving them very slowly and not in lump sums and not enough to get caught up on the rent that they were past due on. And so a lot of this really does have to do with the unemployment system not being very accessible to the residents of North Carolina, and the governor needing some additional time to try very hard to get that system really humming along the way it was supposed to have been and was intended to from the beginning, so that perhaps people will receive their unemployment benefits. Many of them will get that extra $600 stimulus from the government on top of it, and that will hopefully, in his mind, allow them to get much more stably on their feet economically, and hopefully allow them to get repayment plans in place with their landlords. So really what he was hoping is that rather than restart evictions on June 1st, the governor decided that giving people another 3 weeks to try and get some more things, to connect more of the dots really. To try and get more things lined up, to get schools finished for the summer, and to get people hopefully more access to their unemployment benefits that they would be able to use to try and get with their landlords to get repayment plans put in place. All of those things are really one of the drivers here. He also goes on to talk about commercial evictions. I don't think anybody on this call is interested in commercial evictions so much. He does go on to talk about the unemployment rate greatly increasing, and then talks about the federal Paycheck Protection Program, providing financial assistance to small businesses, but they provide only a limited amount, and some commercial tenants are likely to exhaust those assistance provided by the program. True story. And then he goes on to talk about the CARES Act, which, if you've been following along, I've had a number of seminars talking about Section 4024 of the CARES Act, which creates a moratorium through late August that applies to any apartment community that has a federally backed multifamily mortgage loan. And so if you are a property that has a federally backed multifamily loan, then you are prohibited from evicting anyone for non-payment of rent through very late August. You're not allowed to charge them late fees until August the 6th. And late fees are just the least piece of it. But he also says that, but some dwellings and some tenants are not covered by protections in the CARES Act. There's still a lot of uncertainty about exactly what the percentage is of multifamily properties that have multifamily mortgage loans, but at the very least, it's 50-50, and maybe a little bit more. But what that means is that a number of the residents in the state have apartments or rental houses that are not subject to the CARES Act, that whose landlords are allowed to proceed with evictions at any time, even for non-payment of rent. And the governor wanted to make sure that those people are protected as well. So as a result, the governor says it's likely that absent intervention by me, the governor, there will be a wave of commercial evictions in North Carolina. And for these and other reasons, it's reasonable and necessary that the 21-day moratorium also apply to commercial evictions. Fair enough. He does highlight, and this is an important one, in this very next whereas paragraph here, the moratorium on evictions in this executive order does not forgive rent or excuse the obligation to pay rent. You are not absolved of your duties to pay rent. You are simply being given, instead, this executive order gives you a delay. It delays evictions and waives interest, late fees, and penalties that arise during the order's effective period. So what that means is, if you remember, the effective period of this order was 21 days. So rent and late fees that arise during the month of June are waived by the executive order. Whether or not the governor has the power to do that is a matter of constitutional discussion at many levels. The federal constitution, Article 1, Section 10, prohibits any state from making a law or passing any governmental regulation that, after the fact, affects the obligations of contract. So I think if this wasn't a very limited window of time, I think a lot of people would take the position that a decision by the governor to change your leases, waiving late fees, waiving statutory late fees that you're entitled to otherwise under law, would likely be something that should be examined under the auspices of the federal constitution, Article 1, Section 10.
I have a question.
Yeah.
We have a question here, and it says, if we had people we needed to file on prior to COVID, do we still have to wait until August for those, or only wait on our COVID delinquent residents?
So the CARES Act applies to any evictions regardless of when they arose. So if the real question is your property covered under the CARES Act? If your property is covered because it has a federally backed multifamily mortgage loan, then you are not allowed to file for non-payment of rent eviction regardless of when the balance arose. There's nothing in the federal statute that deals with timing of the balance. It only has to do with, are you covered by the CARES Act? Do you have a federally backed mortgage loan? And if you do, then you are prohibited from filing an eviction during this window of time. It doesn't evaluate when the balance arises. It's really only about when do you take the action.
I think we're good.
Anything else from you? Okay. So again, the effective period of this order is 21 days through June the 20th at the latest, which is a Sunday. So effectively through Monday, June 21st. Utility services are also mentioned in here, and the governor goes on to talk about utilities. The Utilities Commission is basically not allowed to disconnect people also. We'll skip through that piece. It's not really applicable to us in any great sense.
Chris, we have a question. Can late fees be charged in June if they are non-CARES Act properties?
Not under the governor's order, no. That's exactly what, in North Carolina, the governor has said that every residential property of any kind, type, or nature, regardless of financing, regardless of whether you own it outright and there isn't any loan at all, the governor's order says you cannot charge people late fees in June, and you cannot evict them for not paying their June rent. Every landlord across the state, regardless of financing type or status or lack of financing, and it's just owned outright.
And does the governor's order, does that apply also to holdovers? We have a question wanting to know, can you file for holdovers such as non-renewals or lease violations?
So yeah, so this issue comes up a decent bit. I've got a lot of clients asking these questions. If you're covered by the CARES Act, if you're not covered by the CARES Act, then there's really no reason to worry very much about anything unless the governor goes back on his word and extends this past June 21st. If you're not covered by the CARES Act, you're exempt from the CARES Act because you don't have a federally backed mortgage, then the governor's order really only restricts you for another week and a half from doing anything. Rather than worrying about holdover issues or anything of the sort, I think it's much better that you wait and simply pursue non-payment cases once we're allowed to again on June 21st. But if someone has turned in a notice to vacate and was indicating they're not intending to renew and were planning to move but then didn't, that's a holdover that obviously is just a regular garden variety holdover that just arose by operation of normal business practices. You're allowed to file that case because it's not a non-payment related eviction. The question, however, that I get a lot is from clients who are covered by the CARES Act, who are therefore subject to the moratorium and aren't allowed to file any evictions at all for non-payment until the end of August. And they want to know, well, can I just not renew people who owe us a balance, whose leases are coming up on June 20th, let's say? Can I just non-renew them and then file for holding over since it's not a non-payment case? And the answer I give to everybody is that I wouldn't file that case because it appears that you issued the holdover notice, the non-renewal notice, because of the non-payment of rent. And if the reason for the non-renewal is non-payment of rent, then filing an eviction and calling it holdover doesn't absolve it of the category of being because of the non-payment of rent, which is what's prohibited under the federal law. So I think that you would be doing yourself a disservice if you tried to simply create the argument that well, we non-renewed them. Well, if you non-renew them because of their balance, then that really is a non-payment of rent related eviction case. The facts would come out in trial, and that would show that the case was not supposed to have been filed because of the Federal CARES Act. Again, there's a difference between a non-renewal or a notice to vacate given because the lease is terminating and the tenant is holding over after they said they were going to leave. You've promised that unit to another resident and you need them to get out. That's a true holdover where they said they were leaving and then didn't. But issuing a non-renewal notice is something you telling the resident they have to leave, and the non-renewal being given because you as a resident were behind on your rent. We're trying to use this as a loophole to the CARES Act prohibition. Loopholes are not the way to go when the federal government is involved. I highly advise people to not try and find loopholes that might put them in violation of federal law. It's a bad idea.
Can late fees be filed or be charged to tenants after the 21st?
Yes, but I don't think you can assess late fees on the 22nd because they don't owe you. The late fees arose on June 6th pursuant to your contract. And so I think the governor's order here makes clear that the fees and charges that arise during the period of the order would include late fees for June. So I don't think you can go back on June 22nd, let's say, and reassess late fees then, because the order makes pretty clear that any fees or charges or rent that came due during the 21 days are waived. So I think really you're just looking at when you get to July, you can restart restart non-payment evictions and also restart charging late fees. Again, unless the governor goes back on what he's telling us and extends the order further out.
Oh, we have tons of questions rolling in. Before you jump, this is a good one that I think people may be interested in, though. It says, if you have already been granted possession in court and the writ had already been filed, but the sheriff did not make it out due to COVID, will they need to refile for the writ? Is there restrictions over lockouts if they were already in process?
Yeah, so table that one, put that one in the agenda for the Chief Justice's order. She mentions existing writs as part of her order, so we'll talk about that when we get there.
All right. Yeah. And then that looks like yeah.
Keep going.
Okay. Keep going.
Okay. So Kim, if you'll, Kristen, if you'll scroll down a little bit. Yeah, keep going. So in these last couple of paragraphs, he's making reference to General Statute 166A, that's the Emergency Powers Act. So he's basically just justifying what he's doing, relying on the statutory citations, legal mumbo jumbo, if you will. And we'll skip down and get to the meat and potatoes here. A lot of references to why I have the power to do this, justifying his actions. Go ahead, keep going. Okay, here's the order itself. Like I said, the meat and potatoes. Section 1, evictions moratorium. All right, so then he talks about definitions. He defines a residential lease, means a lease of a dwelling unit in the state of North Carolina to which the Residential Rental Agreements Act applies. You can't be any more broad than that. If you are a residential landlord and you are renting a residence of any kind to a residential tenant, this order applies to you. Doesn't matter about CARES Act, doesn't matter about mortgages, doesn't matter about anything. If you are a residential landlord in this state in any way, shape, or form, this order applies to you. Again, residential tenant means, of course, the tenant. Residential landlord is the owner of and any rental management company, rental agency, or other person having the actual or apparent authority over any unit in residential lease. So it doesn't matter if your owner came to you and said, well, you're the management company, but I'm technically the owner, not the landlord, so I'll do it. I'll file the eviction action. That's also prohibited. It doesn't matter whether you're the landlord or the management company, you're both covered by this, these definitions. All right, scroll down a little bit. Commercial tenant, commercial landlord. 7, an action is, quote, defined as for reason of late payment or non-payment if the legal basis for that action, the lawsuit, was in whole or in part the tenant's late payment or non-payment of rent. So this is the easy way to answer your question about what if I non-renew them because they owe me a balance. This, when the governor has covered that and says, if your reasoning was in whole or in part because of their non-payment, you're not allowed to file your eviction action. So under this executive order, it would clearly and unequivocally be wrong for you to file a holdover action against a resident who was non-renewed and whose lease expired from June 1st to June 21st as a result of a non-payment issue. And then the effective period, number 9, is defined in B1 below, but it goes down and it says it's for 21 days. If we scroll down, you'll see B1. So it says these restrictions and modifications shall continue for 21 days after the date of entry of this executive order. He entered it on May 30th. That means May 31st was day 1. That means Sunday, June 20th is day 21, which means on June 21st, you can start doing things again. But item A in the prohibition, so scroll just one bit. There we go. Residential landlords shall not, for reason of late payment or non-payment, initiate, which means start a new filing, or take any action to further summary ejectment or other eviction proceedings. That means you can't attend a hearing if there is one scheduled. That means you can't ask for a writ to be filed on an existing one. That means you can't do anything at all to further a summary ejectment or eviction of a resident during that 21-day period. No actions are allowed, whether you're starting a new case or whether you're doing something in an existing case that pushes the process forward. You're not allowed to do that. B, all residential landlords are prohibited from requiring residential tenants to vacate their dwelling units for reason of late payment or non-payment. So you're basically not allowed to give them a non-payment notice. If your lease did not contain a clause that waived the right to a notice and you're required to give a 10-day pay or quit letter, this proceeding right here, this section of his order 1B, would prohibit you from even issuing the 10-day pay or quit letter until June 21st, Monday. If your lease waives notice, then you may not have anything to do other than on the 21st to send them a demand to vacate, which is required before you can start the eviction process. But for other landlords who do have an obligation to provide a 10-day pay or quit, this section means that you can't even start doing that until the 21st. And so then you couldn't file your evictions until July 1st, 10 days after June 21st.
Chris, I have a question that says, what if they skipped? I'm assuming they mean skip their court date. It says, what if they skipped? Are we able to follow the guidelines put in place set by our lease agreement still?
They mean, when they say skip, they mean moved out without telling you. They skipped out on their tenancy. So if they skip, then the rules still apply. If they vacated and turned in their keys, then you haven't evicted them and you haven't initiated an eviction proceeding. So you're not taking any action to further a summary ejectment. No. If the resident voluntarily surrendered the keys and you didn't tell them to in violation of this order, they just moved out, then yes, you would follow your usual procedures relating to security deposits, walking the premises, assessing any damages, and then nothing suspends the application of the Security Deposit Act. So you would have an obligation to deal with that within 30 days of their surrender or possession, just like any other surrender situation. And then
We have we have another question, and it says, if a resident has is past due on rent from May and June, but continues to violate the lease by having a pit bull in the apartment, can you evict for breach of contract even though they are late on their rent?
So the answer to that question is maybe, and it probably would require an in-depth analysis of some specific facts to know for sure. What you can say for sure is that if today you went out to the property and a neighbor complained, hey, I just spent last night getting kept awake by what sounded like a baby puppy in the unit next to me. I've never heard it before. And it barked all night long, and they went in and out, and it's pretty clear that they've got a new dog. And that disturbed my sleep, and I'm mad about it. I feel like that's a violation of my lease rights to quiet enjoyment of my premises. So you know that the puppy is new, and you know that you didn't know about it before until today. It's clear that having an unauthorized pet that happened today in the middle of the governor's order during the effective period, that violation is definitely one that would be allowed to be pursued because it's not for non-payment of rent. You're not, having a puppy has nothing to do with what their rental balance is. If you learned about the puppy today, you definitely could take action relating to that as a lease violation standing on its own. Yes, that's exactly what the governor is intending. If they committed, if tonight there was a drug bust on your property and the cops show up and arrest somebody, that's a lease violation that you can proceed with tomorrow because it's a current event that happens that has nothing to do with rent. It's a criminal activity item. If tomorrow somebody walks into your office and is heated up because they haven't been able to get their refrigerator worked on by your staff for 36 hours and they're mad about it and they start swearing and raising holy hell in the office, that's a lease violation that would entitle you to proceed with a termination and eviction action because it's not related to non-payment of rent. The issue in the question, though, that I would have, you would really want to talk to your lawyer about is if the pet that you're talking about has been there for some period of time, then there's a different analysis that has to be done. And so there's no way for me to answer that question specifically without doing all that analysis. So reach out to your lawyer of choice and ask them specifically, how does the issue of this pet having been here for a couple of months tie into the issue of can I file an eviction or not? The timing of things matters. In other words, when you have a lease violation like that. But if it's a new puppy, there's no doubt that it's a brand new lease violation. You can take action today, definitely.
Now, we have 3 questions regarding communication. Is it okay to communicate and late charges or late fees? I had a question that says, is there anything to prevent us from making collection calls for rent? Another that says, is it okay for us to send out letters? So I think there's concern of, can you tell people that they're, are queuing these rents as they're not paying for them on a month-to-month basis?
Yeah, no, there's nothing in the governor's order that prohibits you from letting people know that they owe the rent. In fact, his order says that it doesn't apply to waive balances or to prevent people from dealing with it. So you can, for sure, send them balance notices, reminder letters. We haven't received your rent yet, please pay. Those are all fine. The issue is you cannot send a letter that is you shouldn't have, and you shouldn't now be sending late letters for June that still say anything about a late fee or that a late fee is going to be charged or has been charged. You shouldn't have late fees on their ledger for the month of June because they're not allowed to be charged by any landlord in the state this month. So that's the key thing, is making sure your notice was correct and making sure the ledgers are accurate. Okay. So then we move on to this 1C, and this one's really interesting. It says all leases are modified. The governor is changing your lease for you in his mind to disallow evicting or otherwise terminating the possession of residential premises for reasons of late payment or non-payment during the effective period of this section. I am confident in saying that the governor does not have this power. It's unconstitutional for him to do this. The issue is whether or not you can prove it, whether or not you can get redress for it during a 21-day window of time. It's likely impossible to get the U.S. Supreme Court to weigh in on the unconstitutionality of this clause before the clause will expire, which is probably why nothing's going to come of it. But just so you know, this isn't allowed. In my opinion, the governor's not allowed to do this. If he was sitting on the other end of this call, I would tell him, Governor, this is unconstitutional. You know it. You were the Attorney General before you were governor. You know you can't do this. But I think his whole point is that he wants it to be a deterrent, and because he knows that there's very little anybody can do to challenge it constitutionally, the deterrent effect of the words is what he's going for, I'm sure, and wants landlords who do know about this order to hear that that is his intent and that he wants them to not do that. So I think he's willing to take that gamble for the purpose of achieving the deterrent that he was hoping to obtain from landlords. So again, they continue for 21 days, and then he goes on and says, for example, if this executive order is issued on May 30th, which it was, the effective period of this section shall be May 30th through June 20th inclusive. June 20th is a Sunday, so that means that on Monday, June 21st, the order will have sundown unless he extends it, which is what it says at the end of that, unless there's an executive order extending this section. So one important thing, and one of the reasons why I have spoken vigorously to a number of my clients about this, is that unless the governor is willing to commit to ending this on day 21, this problem could persist into July. If he decides to renew it, which he gives himself the permission to do in that clause right there, we don't know for sure that all this will go away on June 21st, unless and until he says so and confirms that. And that's why Janae's been working so hard to talk to his people. The board members that actually know Governor Cooper have spoken to him personally. Everyone is trying to get sure that we get clarity on, are you really just yanking on chain here and you're planning on extending this through July? Because if so, that's a different animal. Right now, the word we're hearing is that he is hoping that this will all be over on June 21st. We'll see. Stay tuned. The late fee section is here, number 2. Residential landlords shall not assess upon their residential tenants interest, late fees, or other penalties for late payment or non-payment of rent due to the effect during the effective period. So that includes interest, which doesn't usually happen, but late fees clearly are prohibited, and other penalties for late payment or non-payment of rent due during the effective period. It's not clear whether this would include NSF charges that are otherwise due if you bounce a rent check. The governor's order is not clear as to whether that's a penalty or not. I think that it is probably not a penalty. I think an NSF charge is in the nature of a recoupment, not a penalty. And so I think you probably could still charge NSF fees, but it's not 100% clear. So to the extent that you don't want to be risky, I think it wouldn't be a bad idea to just simply treat NSF fees like late fees for 1 month while this order is in effect. It's probably not a bad policy. And, if the NSF fee happens on June 21st, well, that's something different because then the order will have expired, we hope.
Our unauthorized occupants protected under these provisions?
Every residential tenancy includes everyone who's living in the unit with authorization from someone who is authorized to be there. So even if the occupant was unknown to you, if they were moved in as a boyfriend, girlfriend, or even just a random roommate that they moved in under a verbal agreement with a person who is a leaseholder, unauthorized occupants have rights under the Residential Rental Agreements Act to not be evicted without due process being applied to the leaseholder at least. So yes, unauthorized occupants do get the same rights by extension that a residential tenant does. You can't use self-help eviction to remove anybody from a premises unless they are a trespasser who's broken and entered. Then they're a criminal, not a tenant. Okay, number 3 here is a really interesting one, and this is the one that I get the most questions on, and this is the one that I tell you I don't know the answer to. The governor has tried to create a provision that tells everybody that he wants them to give tenants 6 months to pay their balance. We'll just read it. Residential tenants shall be provided the opportunity to make reasonable payment arrangements. What's reasonable? Who knows? Reasonable payment arrangements to pay off over at least a 6-month period. What does that mean? That means it might be more, like at least 6 months. Any rent that became due in the effective period and was not paid during the effective period. The good news is that whatever this provision does mean, it's very clear that it only applies to June's rent. It doesn't apply to past due balances. It doesn't apply to carryover balances. It only applies to rent that came due during June. No interest, late fees, or other penalties shall be charged on these arrearages. The 6-month payoff period shall be calculated from the expiration of the effective period. So that means that the governor is telling you that if somebody doesn't pay their June rent, you as a landlord are required to give them 6 months from June 21st to pay off their balance, which would generally be Christmas. They have until Christmas to pay off their June rent. Doesn't say what you have to give them. It says a reasonable payment arrangement. And so it's pretty clear that if the tenant proposes something that is a monthly payment of some sort, you're required to take it, according to the governor. If the tenant says, I don't have any money and I'll pay you back before Christmas, that's probably not reasonable, and you probably don't have to give them that power. But if the tenant comes to you and says, I will make 6 monthly installment payments of equal amount to pay my June balance off, that's pretty clear that the governor believes you're going to be required to do that.
Chris, I have a question here that is pertaining to student housing, and it says we have a resident that physically went home to their parents because on-campus classes have closed.
Yep.
The student left behind the dresser and the bed. They did not turn in their keys, and they have not paid rent for the past 3 months. The lease expires July 25th. What are they to do with the furniture?
Well, personal possessions, those always fall under the category of you have to make sure that you get confirmation before you do anything with them. If you use the eviction process, there's a provision in North Carolina law that allows you to dispose of those items once a lockout has happened. But in this environment where lockouts aren't happening, that doesn't help you all that much. And so in the meantime, your best bet is always to continue to bombard the resident or any guarantors on the lease with information and attempts to communicate about the property that's still on the premises, getting confirmation of whether it's been abandoned, whether you have permission to dispose of it. That's always the best approach. Using the eviction process solves the problem for you, but because the eviction process has been hijacked right now, your best alternative to that is nonstop communication until somebody answers your question about what can we do with your property.
And then returning to the 6-month payment plan, are properties that are protected under the CARES Act, are they responsible for the 6-month payment plan as well?
It seems so. The governor is taking June rent, and if you're a residential landlord in this state, then you have an obligation to provide your residents 6 months to repay June rent. I don't think there's any questions or qualms about that, as long as the governor's order stands, unless it's overturned in some form or fashion by legal action. Then this is the expectation that the governor is going to have on you. And the courts, in future eviction actions, the courts are going to look at June's rent and analyze what was required or not required based on that. And of course, if the order isn't extended and it does not apply to July, then you file eviction actions in July if you're exempt from the CARES Act. Then there's really no reason to worry about what happened to June, because eviction actions aren't collection lawsuits, they're possession lawsuits. So really, you're not going to have to worry about it all that much, except when it comes to the time for collection.
And if a lease expires between the 6 months, let's say someone has their lease is going to expire in July or expires in August, is that 6 month window still looming over them? Do they have to? Is there any timeline? I mean, there are no guidelines that were given.
Yeah, that one, there's no way to know because the governor's use of the phrase reasonable payment arrangement. I think when you get to a situation like that, I think it's going to be necessary for you to talk to your counsel and figure out what do we do about this. Is the resident leaving? Are they not leaving? What's the payment arrangement they propose? I think there's a lot of variables, but the governor's use of reasonable gives you some leeway to say we're not required to just take it on the chin. But I think you're going to want to evaluate each one of those on a case-by-case basis with the assistance of your counsel.
I'm going to let you go ahead so we can get to the Chief Justice order as well, and I'll sift through some more questions.
Yep, perfect. All right, so that's that. Commercial evictions, we don't need to worry about that. We can go straight on through to the Chief Justice order. All right, so the Chief Justice on the same day, virtually the same time, did very much the same thing. She filed an order of her own, ordered the Chief Justice of the Supreme Court of North Carolina. She also has some opening paragraphs where she lays out the reasons for the emergency powers she's exercising, COVID-19, and then today Governor Cooper issued Executive Order 142 prohibiting landlords from taking actions to further summary ejectment. She highlights that there are now pending 9,000 eviction cases that need to be resolved that have not been heard since the cases were put on hold by her order on March 16th. And hearing those matters would require landlords to act in furtherance of an eviction in violation of Governor Cooper's order. Again, even attending a hearing would be prohibited. So she says, therefore, additional emergency directives are now necessary to ensure the continuing operation of central court functions. So she is determining and declaring using her emergency power 7839B2 that catastrophic conditions resulting from COVID have existed and continue to exist in all counties. And so she issues these two directives. There's three, but these are the two that matter. 17 says all evictions pending in the trial division, whether summary ejectment or otherwise, meaning summary ejectment or appeal from a summary ejectment, and any other type of eviction, even if it's not a summary ejectment one. So if you filed a claim for possession that wasn't in the summary ejectment process, a common law claim against someone who wasn't a residential tenant, that would also be covered. Anybody who is the subject of an ejectment or other action seeking to have them evicted from residential premises are hereby stayed. All actions in every quarter stayed until June 21st. That's a Monday. It also says sheriff shall not be required to execute pending writs of possession of real property or make due return of such writs until June 30th. She says required. That does give sheriffs permission to continue to execute on writs that are in their possession. So if you have issued a writ and the sheriff has got it in his possession, you could, in theory, call the sheriff's office and try to make a consumer complaint, getting them to do the lockout. The Chief Justice did not prohibit them from doing lockouts, but she also didn't tell them to continue either. She gave them discretion. I am sure that the vast majority, if not almost all sheriffs, will simply not do lockouts until June 30th. And then Emergency Directive 18, she says also, in all summary ejectment proceedings filed pursuant to Article 3, Chapter 42 of the General Statutes on or after March 27th, that's when the CARES Act was put in place, no writ of possession for real property shall issue unless a finding is made that the property which is the subject of the complaint is not a covered property defined by the CARES Act. So that means that every case that's been filed since March 27th or on or after March 27th has to have, as part of the process now, a certification to the court proving that your property, the dwelling that's at issue, is not a covered property. Scroll down. So the administrative office of the courts is thereby directed to promulgate a form affidavit to be completed by plaintiffs in any such action. Again, any action filed March 27th or after. For any summary ejectment or residential eviction action filed March 27th or after, the affidavit shall be mandatory, shall be completed and submitted before final judgment by a magistrate is entered. So that means that for the 9,000 cases that are pending currently in the court system as of the date of this order, every one of those has to have an affidavit presented to the judge no later than at the time of the hearing on those 9,000 cases. For any summary ejectment action filed on or after June 1st, the affidavit must accompany the filing of the complaint itself, such that a copy of the affidavit will accompany the summons and complaint when served on the defendant by the sheriff. So as of June 1st, there is a mandatory obligation that every landlord for every case prepare and submit an affidavit that the courts have prepared. And we're going to talk about the affidavit here next. But just be aware that that affidavit also has to be prepared for cases that you filed previously that are in the queue right now. So if you have active cases that you're waiting on a hearing, you're going to hear from your attorneys that you need to submit the affidavit. They need to get the affidavit prepared so that when the hearing happens, they will have it and can hand it to the magistrate. But you're also going to hear that as you file new cases, you're going to have these affidavits completed along with the paperwork for the complaint summons so that they all will be served on the defendant. Each tenant will receive a copy of all of those three forms: complaint, summons, and CARES Act affidavit.
Question for you, Chris.
Yeah, go for it.
Question says, on June 21st, we will need to send the normal 10-day letter and file court papers on June 3rd. Like, will they need to send the normal 10 days letter prior to filing on June 3rd, July 3rd, excuse me.
July 3rd. Well, I'm not sure what's special about July 3rd, but assuming the governor's order expires on June 21st or on June 20th, then if you, July 3rd is probably, I think July 3rd is a Tuesday, isn't it? Anyway, so if you send a 10-day letter on June 21st and it expires on July 1st, which is a Monday, then on July 2nd, you could, in theory, file eviction actions based on non-payment of rent based on those 10-day letters. Yes, you could.
Another question says, what would your recommendation be for a property with a non-federally backed loan but are trying to refile to HUD and hold off on evictions, or should they hold off on evictions or proceed?
Oh, that's one you're going to want to send as a specific email to your lawyer, whether it's me or somebody else, and ask them to that's an operations question that needs a lot more analysis than I can cover today. But yeah, those are questions that are convoluted. There's a lot of fact-specific inquiries that need to be made.
And then this one says, we had been granted possession of an apartment before March 27th, but we are a CARES Act community. Can we proceed with a lockout?
It will depending on if you're covered by the CARES Act, then there's a provision in the CARES Act that allows the property to seek forbearance from their mortgage. And so if you sought forbearance from your mortgage, or if your owner has asked his lender to forbear on his mortgage payments, then no, you can't, because while you're in forbearance, you have to prohibit, you are prohibited from seeking evictions. So the answer is you have to look at the facts and circumstances before you know for sure what you can or can't do. But as we saw in the Chief Justice's emergency directive, even if you were entitled to a writ, the sheriffs aren't required to do anything with those until June 30th or after, no matter what. Even if you don't have forbearance, even if you would otherwise be allowed to proceed, you still have sheriffs that aren't obligated to do anything past until June 30th. What else?
And I have another question that's curious. It says, if a resident is not being responsive, and this is in regards to the payment plan. So if a resident is not being responsive to the payment plan through contact attempts, can they begin the eviction process once the CARES Act restrictions are lifted?
Once the CARES Act moratorium ends, yes, then everybody is free to go about it. There's a provision in the CARES Act that relates to how you restart the process. The moratorium itself ends on July 25th, day 120. But the CARES Act currently contains a provision that says once you get to July 20th, you can't start an eviction process on anybody for non-payment of rent until you've given them a 30-day notice and opportunity to cure, basically. And so for a CARES Act property, you have a two-step process to restart evictions. One, you have to wait until July 25th. Two, you have to send a letter on Sunday, July 26th or Monday, July 27th, giving people 30 days from that day to pay rent or move out, even though North Carolina has a 10-day provision. This federal statute says if you're covered by CARES Act, you have to give them a 30-day window, which means you can't start eviction process on anybody under a CARES Act property for a non-payment of rent case until August 26th at the earliest.
Someone is looking for some clarity. They're asking, can we file for June evictions on June 21st and just not charge a late fee?
No. The governor says you have to give everybody June's rent in a payment plan. So you can't file to evict anybody for non-payment of rent unless and until they don't pay July.
And then there was another question about bonds. It says, have rent bonds been canceled?
No, they have been continued by order of the Chief Justice, and the deadline for all of those rent bond payments to be made is now extended through at least June 21st. But the obligation is still there, but the timing of when you can figure out whether they've made their payments or not will run at least through June 21st.
This is another question pertaining to a 6-month repayment period in June. Does the resident need to sign a payment agreement if they are non-responsive and do not do that? What would we be able to do? Would we be able to decline to accept July rent and move forward with non-payment for the month of July?
That one I don't know. It's going to require some clarification from the governor when we get to that point. There's no real way to know for sure exactly how the governor would envision that. And so I think those kinds of questions you're going to want to wait for further guidance from the governor's office. And if you don't get any between now and June 21st, then reach out to your attorney and ask them for suggestions about how to handle July rent when it comes due. If people have been non-responsive, if a reasonable payment plan hasn't been proposed, what do we do? And the answer is, I don't know. I don't know what the governor's envisioning. I don't know what he would say the obligation is or isn't. I think it's fair to assume that if the tenant hasn't talked to you, then they haven't proposed a reasonable payment plan. And so what does that mean for June's rent, July's rent? There's just a number of issues that are all tied together, and the governor did a very bad job of anticipating all those issues, and he issued this order with much less clarity than is needed to answer all those kinds of questions. It's just hard to know.
Can you send an account to collections that defaulted prior to COVID?
Yeah, there's nothing about the CARES Act or this executive order that relates to collection activity. It only relates to eviction activity.
And the payment agreement only applies to June rent. Yes.
That's right. Repayment agreement only applies to June rent. So if they still, if they haven't paid half of April or May, and now June's coming, they haven't paid that either, you only have to, under the governor's order, you only have to allow them a 6-month repayment plan for June, but that doesn't have anything to do with half of April or May. Once the time period runs out, you could file for eviction based on non-payment of May rent, if need be.
Awesome.
Emergency Directive 19 right here on the screen. This is one to keep an eye on. The Chief Justice has created a voluntary mediation program for summary judgment actions. They are going to try very hard to create an opportunity for all landlords who are in the 9,000 case category to get a volunteer mediator to serve as an opportunity for you to try and resolve cases before your hearings get scheduled, because in some counties it may take quite a while to get your hearings done. So keep an eye out for notices about voluntary mediation programs as they are created. It may be an opportunity for you to sit down with your resident and get a plan in place for getting things resolved, which we normally would do in the hallway of the courthouse, but now we may be able to do it as a voluntary mediation program. And then lastly, let's show them the AOC form so they know what it looks like before we sign off. So this is the CARES Act affidavit. This was created by the Administrative Office of the Courts. It's very straightforward. As you can see, it references Emergency Directive 18 of the Chief Justice's order right there on the bottom right. And then if you scroll down, you'll see the questions that are required to be answered are pretty specific and pretty require a pretty good level of information. You have to tell the court who you are, what the address of your community is, the address of the leased premises that's involved, and then you have to tell them, number 3, the premises is or is not a covered dwelling defined by the CARES Act. That's a specific definition that's under the statute. Then question 4 asks, does the property participate in a covered housing program or rural housing voucher program under the Housing Act? For example, low-income housing tax credit properties, Section 8 voucher programs, and other programs related to subsidized tenancies for seniors, the disabled, etc. Those are all possible kinds of properties. 5, does the property have a federally backed mortgage loan or a federally backed multifamily mortgage loan? I don't know why she included 5, because 5 is the same as 3. Are you a covered property requires you to know the answer to this question. The premises is or is not a covered dwelling. I think this is here because she wants a lot of the smaller operators, the mom and pop landlords, as we say, to have multiple questions that give them enough information to know how to properly answer these questions. So I think that's why she included 5, just as a safeguard. And then 6 is the important one. The information relied upon me in making this attestation is the following. You can't just say I'm not covered. You have to explain to the court why you believe that to be true so that the judge can decide whether they believe you actually know the answer correctly. So all of our clients know that we've been requiring them to give us letters or affidavits from either the lender or the owner of the property attesting to the fact that this loan isn't a federally backed multifamily mortgage loan, or I'm the owner of this property and I don't have a mortgage at all. Those are the kinds of pieces of information that the court's going to look at in these affidavits. If you're doing it yourself and you're not using a lawyer, you should expect to be required to provide some high-level documentation, not just your own personal statement that I don't think I have a Fannie Mae loan. That's not going to do it. So make sure you're ready for thorough analysis and to be able to be ready to show your work, as they used to say in 5th grade math. The judges are going to be looking, and that's what question 6 is all about. And that's that, folks.
I have a quick question that came in, and it says, can residents be filed through your website before the days mentioned to be in the queue, so to speak, for when the moratorium ends?
Well, we're accepting cases from everybody. If it's a non-payment of rent case, then we're simply going to get it ready and hang on to it until Monday the 21st. If we're allowed to file them on Monday the 21st, because the governor lets his order expire, as he is hopefully going to live up to, then we'll have the cases ready and we'll file them on the 21st. So yes, if you've got cases, we'll be in charge of making sure they're ready to roll when the time comes. No reason not to send them to us.
And then this one says, what happens if our lender is not providing us with this document for not being a federally backed property?
Well, then I think now that you have this affidavit and this executive order, you can take this executive order, the link that Janae is going to send, you can take that and send it to your lender and say, I'm required, I need you to give me this statement, it's not optional.
And another question, it says, if Loebsack is our attorney for an active eviction, are they filing out of this affidavit for us?
Yes, we sent out an email to all of our clients once the affidavit came out, telling everybody that that's part of our service. And unless you want to do it yourself to try to, then yes, we handle those. That's why we've been doing all this work gathering this documentation. I knew this was coming down the pike. It was inevitable.
Well, we are right at 2:04, and we try to be mindful of everyone's time. Chris, thank you for taking the time to sit and break this down with us as always. Thank you to our affiliates for sharing this link and providing the information to our members. Thank you, participants, for joining us today. We will continue to do these legal webinars and provide this information as it is forthcoming. I know that the governor's executive order, particularly with the 6-month payment plan, is very ambiguous right now, and more information is needed. The minute we receive any indication that clarity is coming, we will provide that to you guys so you can be prepared on what to do next. If you have any questions, please feel free to reach out to us. As always, if you came in late, the full recording to this webinar will be provided to all of the affiliates, and they will be able to distribute this link to you all. Thank you for joining, and I hope you enjoy the rest of your day. Thanks, Chris.
Thanks, Janae. You did a great job. Appreciate it.